Hello the internet, hello Jason Isaacs, hello to all of my politicos out there. Okay, so something a little bit different, or well, not entirely different, I've done it before, but I thought I'd include it again. What we've got coming up now is a video that was recorded in front of a live classroom audience on Constitution in the UK. So I hope it works. I hope you can make out the details. If you are struggling to get a hold of the information on the PowerPoint, please do give me a shout in the chat, and I'll see if I can't get you a PDF of the PowerPoint presentation. And as ever, do come back to me with your questions. We've just had the guidance from the government, which suggests that the content of the content in the 2022 paper on the Constitution is going to be slightly scaled back. It's going to be scaled back. I think it's still going to be there in a big way. So that's one thing we've learned just today, today being the 7th of February. The other thing I've learned is that I urgently need a haircut, so I will get on that as soon as I possibly can. But please do come back to me with your questions, ideas for video. I'm always very, very interested to hear those, and I'm, somewhere where we need to do a bit of work, then happy to look into that. But enough from me. Got a video coming up on the British Constitution. I hope you like it. If you do, let me know. If you don't like it, well, you can let me know about that as well. I'm big enough to roll with those particular punches. So here comes the video. Like and subscribe, and enjoy politics. See you all very soon. Take care now. Bye. Right. So, British Constitution. This is basically a sort of summary of the way in which my thinking's evolved on this, and hopefully it's going to help you as we go into the exam. So, what is a constitution? We've talked about this a great deal in the past, and what we've tried to do is bring in the concept of the civil state as well. So what is a constitution? Well, the constitution basically describes the civil state. And it's a combination of principles which works basically as a contract. This is what the government is for. Well, this is what the civil state indeed is for, and indeed how that state is then going to be laid out. So it's the institutions of the state and really what it's for, and then that in combination creates that concept of the civil state. So that's the constitution. What is a constitution? Hopefully that's fairly clear. Now, this is the British Constitution. Does anyone know, for instance, does anyone know what this is? I mean, obviously I just told you it's the British Constitution, but what is it? What are we looking at there? Bills. Bills, or rather acts of parliament. Bill is the one that goes in, the act comes out. These are all the acts of parliament, or at least some of them. Do you know what they're written on? Some of them anyway. No.
Sheep's calf.
Calf, vellum, which is the skin of an unborn calf. Anyway, point is, when we're looking at the British Constitution, we need to remember that it's two things. It's that organic document and it's flexible. Organic because it's evolved over time, and I think we all know about that. I'm going to go into that in much more detail. And it's also flexible, but not infinitely so. Something has to be fixed. If nothing's fixed, if you can do anything you like, then basically what are you looking at? Tyranny, or arbitrary government, essentially. There are no checks, no balances. The government can do anything that they like. So there has to be something that limits what the state can do. So, critically, in our system, the Constitution is anything Parliament says it is, because we live in a parliamentary system. This is the nature of the parliamentary system. Our Constitution is whatever Parliament says it is. Now, that probably seems a bit weird, okay? But this is the product of evolution. This is something that has evolved over hundreds and hundreds of years. We never had that revolutionary moment. We never had that Etch-a-Sketch moment, or the factory reset moment, or that sort of stuff. Anyone know off the top of their heads how many factory resets France has had?
13.
No? 4. No? 5. They're on their 5th republic, and the 5th one started once they got rid of the aftermath of the Second World War, which didn't go particularly well for France. But anyway, we've never had that. America had one, and they're still on that constitution, so that's the one and only constitutional settlement that they've had. France is on 5. People stopped counting in Italy. Of course, Russia's had several because they've had to reboot a couple of times. But we've had this ongoing system, this ongoing evolutionary document where the British Constitution has evolved through time. But something has to be solid. There can't be entirely arbitrary. It can't be just up to Parliament what it is that they do. And the first thing to remember is that the solid things, the immutable things, are the principles. The principles of the British Constitution have, as Dicey has said, emerged through the mists of time. So here we've got Dicey, the general principles of the British Constitution arise not from the declaration of the rules, but from the decisions made in individual cases by an independent judiciary. What the hell does that mean? Wesley?
Over time, through like a heuristic process, they've come into force based on what's worked.
Okay, absolutely. That idea of heuristic process, I really like that. Fundamentally though, who does not get to say what the Constitution is? Monarchy? Judiciary? That's tricky, but we'll come back to that. Sorry? Well, basically, whoever the rulers are. So Dicey here is saying, look, it doesn't matter who the rulers are, they don't get to say what our Constitution is. They don't get to determine the constitutional principles. The only way we can identify those constitutional principles is by looking back at hundreds and hundreds of case law, hundreds of years of case law. So it's the decisions made in individual cases by an independent judiciary. When we go back and we look at those hundreds of years of case law, what Dicey is saying is that we can infer from that certain key principles that are completely inviolable. You in pain? No. All right, cool. What are those 5 principles? Okay, so they are rule of law, yep, peace, parliamentary government, parliamentary sovereignty, unitary state, and the constitutional monarchy. Great. And for those of you who are following this online, don't worry, that's on the next page. So these principles have emerged, they're absolutely solid, they can't be changed. Dicey has essentially fixed those when he wrote that particular essay. And then we get to decide how we apply those in real terms. Well, that's given up to Parliament. Parliament decides how these principles are going to be applied. Why Parliament?
They're elected.
Because they're elected. These are the democratically elected representatives, and so they are basically allowed to define what our civil state looks like at any given time. Good. So, as we said, these are the 5 principles of the Constitution, and they run all the way through that state, all the way through that case law, like right through a stick of rock. Yep. Rather like if you're looking at a band's back catalogue, whether it's the Beatles or whether it's the Radiohead, you can look back there and see those themes emerging, themes that are constant across every album until Yoko comes in and breaks the law. It wasn't Yoko, I know, but anyway. Right, so above all the principles, and then we have the sources. So these are where we find the British Constitution. So statute law. Why is statute law the top one? Why is statute law the most important one? Sorry?
The one that's enforceable in the courts.
It's the only one that's enforceable in the courts, absolutely, but why is that? Because it's the will of Parliament, and Parliament are legal sovereigns because they are democratically elected. Good. So they're up there. Common law, we know all about, I hope. Constitutional convention. Okay, what are our gun examples of constitutional convention? Everyone knows the Salisbury Convention, and it's always the Russians who mention it. You've been to Salisbury recently?
No, recently.
Can you prove that? So Salisbury Convention. What other conventions have we got?
Is it royal prerogative?
No, the royal prerogative is actually part of common law.
Wasn't like military.
Ah, good. Well, we'll come to that one last, actually. Ministerial responsibility, that's effectively a constitutional convention. Cabinet government, that sort of thing, that's all constitutional convention. Cabinet, gov, there we go. But the one that's really interesting here is the vote in Parliament before military action, prior to military action. Unless it's on a Friday and you're Theresa May, in which case you launch the missiles anyway and get retrospective permission on the Monday. But in theory, we have a vote in Parliament prior to military engagement, and of course, we all know who found themselves frustrated by that. Who wanted to invade Cameron in Syria in which year?
2008.
12.
13.
Good. So, statute law, common law, constitutional convention, works of authority. Works of authority. We've already mentioned Dicey. We've got Walter Bagshot there, which is interesting. This one, I can't. This is Geoffrey Marshall, who wrote a book in 1970 called the British Constitution. He was my tutor, but he hasn't been inducted yet. But Erskine May has. So Erskine May is an old one. Erskine May's been in the news recently. Anyone caught up on why Erskine May's been in the news? Okay, let's go and have a look at that.
May not accuse each other of lying or deliberately misleading the House unless such a substantive motion is under consideration.
Terrific stuff.
Erskine May is clear that it is to preserve the character of parliamentary debate, which I take to mean to stop it descending into fruitless cycles of accusation and counter-accusation.
Yeah, well, he did a great job, because as we all know, the standard of parliamentary debate recently has just gone through the ceiling, so that's absolutely brilliant. So he's there, the speaker there is quoting Erskine May in terms of parliamentary procedure, and he's actually, I think, referring to that particular text there. That, by the way, is Politics Joe. If you haven't subscribed to that, it's hilarious. It's very, very good. He hates Cameron, he hates the Conservatives, so it is polemic, but he's got some great clips up there, so do look out for that. Treaties and laws of the EU, well, obviously, those no longer apply, but they may ask you about that in the exam, so you just need to know that that's out there. Cool, yeah, great. So, the Constitution and the principles, we've got the rule of law, we've got parliamentary government, unitary state, and constitutional monarchy. I'm going to talk a little bit about these in a minute, but this is all bundled up. The Constitution rests on those 5 principles, but the actual application of those principles is given over to our parliamentary masters, to our parliamentary representatives, so they can apply it on a day-to-day basis. So we have this organic constitution, really nice quote there from Adam Tompkins about how the nature of the constitution has evolved over time. A curious admixture, which apparently is a word of a variety of times. Splendid. Now, there are certain historical moments of note that you need to know about in the Constitution. It's in the spec. You're not going to be asked about them as such, but they may come up. And in terms of understanding the constitutional monarchy, well, these are some of the critical moments in our history that will help explain that. We start off with the Magna Carta. Now, how many times have you been in an argument and somebody said, well, the Magna Carta is all about democracy? Now, maybe you haven't been in as many Twitter spats as I have. The key thing is the Magna Carta is nothing about democracy, and yes, I'm talking to you. Not you, Tony, somebody online. Anyway, the Magna Carta is nothing to do with democracy. It is, however, about limiting the king's power. This is the first breach in the king's armor. It was the first time when somebody turned around to the king and said, oh, hang on a minute, you're taking the whatever, and we'll rein it in from there. And then over time, that has continued to evolve. More and more limits have been put on the king. Particularly at this point, particularly in this point here, where the whole nature of the relationship between the crown and the country and the state changed dramatically, right up to the point where the Act of Settlement in 1701 basically said, well, Parliament, not God, is going to choose who's the king. So what we have is a monarch now, a constitutional monarch, who operates within the Constitution. Now that's much more detail than you're going to need in the exam, but there it is anyway. It's on the spec, so that's it. So these things in combination, all of this in combination, helped us to get to the point where we are today, where we have a constitutional monarch whose powers have essentially transferred across to the state in the nature of the crown. So the crown now holds those powers previously employed by the king, and that's the nature of the royal prerogative. See other videos. Yep. Cool. Okay, next one is the unitary state. Again, this has evolved over time through a succession of laws. Now, once upon a time, we had all of these different countries. Now they have all been folded together. So the Union of Crowns saw the King of Scotland become the King of Greater Britain. The Act of Settlement saw English law being justiciable in Scotland, thereby essentially wiping out big chunks of the Scottish legal tradition. Although, of course, they do still have their own legal system, but let's not go into that right now. The Act of Union took that Scottish settlement and took the Scottish Parliament and folded it into the British, the wider British government. And then we have the Devolution Acts, which of course take a bit of that power and give it back to the regions. So all of this in total has led to the creation, or has essentially established the effectiveness of the unitary state. To what extent does the devolution challenge the unitary state? Does devolution challenge the unitary state? No, why?
Because power still lies in.
Because power still lies in Westminster, because what we've got is a situation whereby Westminster takes its power, or takes some of its power, and gives it to the regions. It gives a lot to Scotland, it gives some to Wales, it gives other bits to Northern Ireland. But whatever Parliament giveth, Parliament can taketh away. So that intrinsic power remains in Westminster. And of course that's different from the federal system, because in a federal system, where's the intrinsic authority? The states. You've got the United States of America. The states existed before the Union did. So the intrinsic authority resides there. And actually, when we get to the Constitution in 1789, of course, we see some intrinsic power given by the states to the federal government, so power is essentially shared. Yes, Anna?
De facto, though, isn't it quite hard to take it away?
Oh, absolutely, yeah. De facto, it's, take that power back from Scotland and it's going to cause a riot. But the interesting thing is, if Scotland then decides to vote for independence, then that's really going to challenge the unitary state. But interestingly, in the powers that were given to Scotland in that Scotland Act, they do not have the authority to call their own referendum. Only Westminster can call a referendum on Scottish independence. So if, what's her name? If Nicola Sturgeon calls a Scottish referendum, that technically will have no force in Westminster, but it would have no de jure force, but of course it has massive de facto force. Yep, and that's one of the reasons why it's a bit tricky at the moment. Okay, so that's the unitary state, again, evolved over time through all of these legislative moves and practices. Any questions on any of that? Brilliant. Whoops, didn't mean to do that. Okay, so now into the operation of Parliament, more reform in terms of the operation of Parliament. My board has decided to go nuts. So again, will you be tested on the Great Reform Act? No. Will you be tested on the expansion of the franchise? No. Will you be tested on the Parliament Act? Yes, you will. You will need to know about this. And will you be tested on Europe and the EU law? Maybe. Okay, it's still in the spec. So they have said that it's still in the spec. They may change their minds on Monday, but as of now, it is still in the spec. But to be brutally honest, that's about as much as you need to know. Anyway, Great Reform Act, we see changes to the way in which Parliament operates, the abolition of rotten boroughs. Big step forward towards democracy. We've still got voting qualifications, and women are specifically denied the vote. Again, are you going to mention that in an essay? Probably not, but you need to know that it's part of the evolutionary package of the British Constitution. Again, here we can see the way in which the franchise expanded over time, starting basically in 1832. Women get some women get the vote in 1918, and then we finally wind up with universal suffrage for those in all those over 18. Apart, of course, from those in jail, although that has, of course, been challenged in the European Court, and technically we're in breach of that European Court judgment. But Representation of the People Act votes for everybody except prisoners. Parliament Acts, well, you know all about this anyway, so I don't need to explain that right now, but that again is changing the nature of the government, the operation of Parliament. And with the EU, we've got, going into Europe in 72, EU law is justiciable in the UK and superior, of course, to statute law, because we passed the statute law that said it was. And then in 2017, we have the notice of withdrawal, we leave, and EU law is no longer justiciable in the UK courts. Interestingly, most EU laws are still in place. There hasn't been a great big bonfire of EU legislation. I was just looking at the Working Time Directive with the lower six the other day, which essentially limits you to 48 hours a week. That was EU regulation or EU directives. It's still in place. Can anyone remember there was a massive excitement when we did get rid of one EU regulation?
Fish.
No. We're still fighting that one over the French. But technically we're British fish for British fishermen, although the French aren't very happy about that. The French are never happy. But what significant change was introduced basically on the day we left the the EU? Anyone remember it?
You couldn't get speeding tickets?
No, you can still get speeding tickets, trust me on that. But no, it was it eliminated VAT on sanitary products. No? VAT was chargeable on sanitary products. It is no longer chargeable on sanitary products. It is in the EU, but not in the UK. Hooray! Brexit was worth it. That and the blue passports. All fantastic. Good. So, let's have a look at our constitution then. So, we have that established and inviolable set of principles, the 5 of them: rule of law, peace of, PGov, unitary state, constitutional monarchy. Again, if Scotland leaves, what's that going to do to the unitary state? Well, who knows? However, there is sufficient flexibility in the application of those principles to allow the constitution to evolve and flex over time. That is the nature of the parliamentary system. Parliament at any given time says what our constitution looks like by passing laws. Every time Parliament passes a law, our constitution changes a little bit. And the good thing about this is that what that means is that the shape of our civil state is determined by our democratically elected officials. And of course there we're leading into an obvious contrast with America, where the civil state is ultimately designed or controlled or created by whom? The Supreme Court. Absolutely. Good. So we have the set of principles. They don't change. The day-to-day application of those principles is controlled by Parliament. Parliament is our legally democratically elected representatives. Therefore, we live in a democracy, at least until Boris sorts that out. Okay, let's flick across very, very quickly and just contrast that with what we've got in America. Also, before that, we should probably look at the weaknesses of the Constitution. So we do have some entrenched peculiarities. Constitutional monarchy and the unitary state, as I said, probably about to go through a pretty rough spell if Scotland presses ahead with moves towards independence. The principles are not justiciable. This is really, really, really important. The principles are not justiciable. Why are the principles not justiciable? Sorry?
They're not statute.
They're not statute law, and our courts are courts of law. We do have courts of justice as well, but what we're looking at here are courts of law. So you cannot use the principles in court. Now, if we go back to the Anti-Terrorism, Crime and Security Act, remember that?
Yeah.
Yeah, what year?
2004.
2001. So what did that allow us to do?
Lock up potential terrorists without trials.
Well, they didn't have to be potential terrorists. All they had to be were foreign nationals who we could not safely deport. So those foreign nationals who we could not safely deport because of that pesky HRA, we said, or the Anti-Terrorism, Crime and Security Act gave government the right to put them in jail without trial. Now this was declared incompatible with the Human Rights Act, or the ECHR, in AFC and others, FC versus the Home Secretary of 2004. So basically these guys spent 3 years in jail without trial in Belmarsh. But when the House of Lords, as it was then, it wasn't the Supreme Court, when they handed down their verdict, they had to say that the Anti-Terrorism, Crime and Security Act, so nearly the Act, so the Anti-Terrorism, Crime and Security Act of 2001, it's a really complicated thing, but basically it was incompatible with the Human Rights Act, and rather the government's derogation from the Human Rights Act was not justifiable. One judge, Lord Nichols of Birkenhead, memorably said that the indefinite detention of individuals without trial is anathema in any country that claims to recognise the rule of law. So he actually brought the rule of law into the fight. And I often imagine all the other judges at that point kicking him under the table and going, "Shut up, Nichols. We can't go there. We're not a constitutional court." So the principles are not justiciable. And right now you should be thinking, well, hang on a second, what about Miller 2, which seemed to hinge on parliamentary sovereignty and parliamentary government. That's a very, very complicated thing. I don't have time to go into it right now, but when you look into the Miller 2 judgment in full detail, it is evident that it was not based on parliamentary systems, on constitutional principles, because obviously they couldn't do that. But I haven't got time to get into that right now, but I will get at that later. You cannot protect rights from Parliament. This was, somebody said this in a lower sixth class just the other day. I thought, that's a really nice Really, really nice way to put it. You can't protect rights from Parliament. What sort of legislation do you think might demonstrate that particular idea? Well, the Human Rights Act's out there. That is protecting our rights in theory, but SOCPA, date?
2005.
Well done. 2005. Any others?
The one that's being
LASBO,
the one that's being passed right now, or trying to get passed.
2012, and the Police, Crime, Sentencing and Courts Bill, as it is now. All of these arguably are incompatible with our human rights. SOCPA, if you remember, significantly restricted our right to protest. LASBO created, basically it slashed and burned its way through the provision of legal aid, so very, very difficult for people to have their day in court. And Police, Crime, Sentencing and Courts Bill, well, who knows what the hell that's going to say, what on earth that's going to deliver. Of course, that's just been kicked back by the House of Lords. They said, we're not passing this, and then went straight back to the Commons. So this is still in a game of parliamentary ping pong, but that is just going to cut a massive swathe through our rights. The job of the courts, of course, is to try to reconcile all of these bills with the Human Rights Act. So there we see the benefit of the doubt accruing to the democratically elected officials. The courts are obliged to try to find a way to shoehorn all of this legislation through the Human Rights Act. And when they do that, to a great extent, they're focusing on the difference between that and that. What's your favourite phrase, Alexander? When they're looking at SOCPA, has that restricted your right to protest?
Sure, yes.
Sorry?
De jure, yes.
De jure, no.
Oh, yeah.
De jure, no, because you can still protest, you just have to ask the police if they don't mind if you protest. De facto, has it restricted your right to protest? Oh yeah, absolutely, because now you can't protest there, but you can protest here. Yep. LASBO, has that restricted your access to court?
No.
De jure, no, because you can still go to court, you'll just have to represent yourself or sell a kidney or bankrupt yourself, whatever it is. So de facto, yes it has, because you can't afford to go to court. And we'll wait to moan about that one when it finally comes up. Yeah. So you can't protect human rights from Parliament. There are inadequate checks to prevent the concentration of power in the executive because largely of the weakness of Parliament. All of this comes down to two things. It comes down to the fact that Parliament cannot do its job, or Parliament struggles to do its job because it's not neutral, independent, or expert. And instead we have a system that's reliant on good people doing the right thing, and what we're seeing right now is a very clear bit of evidence of what happens when bad people do bad things. It's very, very hard to stop them, particularly when you have the compliant majority in Parliament. So those are the weaknesses of the British Constitution. We can chuck those into an essay. I think it's really nice and straightforward. Pick three. Again, as we flick across to the United States, the situation changes. The United States, yes, we've got a clear and established set of principles. We find them in the Declaration of Independence and in the Articles of Confederation. Now, remember the mark scheme, the specification gets this wrong. Yeah, I'm saying that as a record. The constitutional principles of America are not separation of powers. Okay, that is a means to an end. The principles of the American system are primacy of the individual, primacy of the state, government by consent, democracy, and protection from tyranny. Those are your principles. Now, in the exam specification, they're asking you to talk about separation of powers and whatnot and what have you. The Bill of Rights. The Bill of Rights is not a principle; it's a thing. You'll worry about that later. Key thing is these are the principles. Then they're put into effect in the Constitution, where you have entrenched rights, federalism, separation of power, checks and balances. So this is the end. These are the means. These are the ones that you have to talk about in the exam. And then in terms of constitutional flexibility, again, de jure, you can change the Constitution through the amendment process. De facto, we have points of constitutional flex where the Supreme Court can come in and say, well, we're going to do it that way, or we're going to do it that way. If you need to go, that's cool. So they're not actually in the Constitution, but it's established by precedent and indeed convention with Marbury versus Madison 1803. And I think once we get this last slide out, then we can do it. So aspects of the Constitution no longer work. It's out of date. It was written for, written in pre-internet times, pre-nuclear weapons, all of that. But critically, it was written for 13 states. It was written for 13 small, very, very similar white Christian states who had just fought a brutal battle with the UK or Great Britain, and who were trying to establish their own hegemony. So the Constitution is categorically out of date. The de jure amendment process is no longer effective because the threshold for change is so dramatically high, and America is so terribly polarized at the moment. And instead, it's fallen to the Supreme Court to try to stretch and tease stuff through the Constitution. SCOTUS therefore becomes the final arbiter of policy. All actions of other elements of the state, whether it's the states or Congress or the President, are essentially provisional, pending review in the Supreme Court. And so the Supreme Court essentially becomes the architect of the American civil state. And I think we all agree that that's problematic at best. And that, I think, is it. Thank you very much to my live studio audience who've been incredibly helpful. And they're now ready to go off and do something else. I hope you found that useful, and I should cover that up. I hope you found that useful, and I'll see you online. Thank you. Goodbye. Okay, so we're back in the studio / office, and I hope that helped. Again, do let me know if you've got any questions, suggestions. You want a PDF of that particular document, then we can probably get that to you. Otherwise, keep working hard, and I'll answer such questions as and when they come through. So take care. Speak to you later. Bye now.